According to the new report by the Institute of Race Relations, the Constitution's broad civil liberty provisions aren't always recognized or properly administered by the courts. The report's release follows public outrage over the circulation of video footage of an assault by a VIP protection unit. So to discuss this further, I'm now joined by Head of Policy at the Free Market Foundation, Martin van Staden. Martin, thank you for your time and good morning to you. I want to start with the report and what it tells us, just when it comes to the leeway that it seems courts have now given to just government in general when it comes to, constitutional rights within South Africa. What do we find in this report?
So we all know South Africa's very tumultuous history when it comes to civil liberties, and the Constitution was very much adopted as a way to put that history behind us. Part of this is what has been derogatorily referred to as the Weasel Clause, Section 36 of the Constitution, which provides that government, of course, may limit constitutional rights. And Section 36 provides what I would say is a very strict and clear set of guidelines. In fact, a process, a compulsory process, not just a guideline, that government must comply with. In fact, government must justify any limitation that it wants on South Africans' constitutional rights according to that provision, and the courts must apply that provision very strictly. Now, the report looked into whether that has been the case and found that, in fact, no. So, of course, it's not all bad. The courts have stood up for constitutional rights, but Section 36 demands a far higher standard than what the courts have, in fact, been implementing in practice. So that is what the report ultimately looks at.
Yeah. So in essence, we're seeing that in terms of application, excuse me, Martin, in terms of application and acknowledgement by the courts being properly applied here, in as far as civil liberty and the Constitution are concerned, there are some gaps that equally need to be addressed. Yes, we're saying that they have applied and acknowledged in some, but in others they have not.
Yes, that's exactly the case. It's the haphazardness, in fact, of the application of Section 36 has been the problem. And in fact, the courts have acknowledged that there cannot be one strict formula for how it must apply. And to an extent, that's correct. You must have regard to the circumstances of an individual fact set that comes before you. But you must always, as a judge, insist on that very high standard. So, I mean, we have cases all the way up to the Constitutional Court where constitutional rights have been limited, and the court says as much. And then Section 36 is simply not applied at all. One can think of maybe the 2012 Constitutional Court case of Agri SA. People will know this as the case where the court said that the nationalization of minerals in South Africa did not amount to expropriation, but only deprivation. And the court acknowledged this in the words, in the mouth of Chief Justice Mogoeng, but then did not apply Section 36, which would have to be applied when deprivation does occur. And during the COVID-19 lockdown, we had several high court cases, the FITA matter, the ESAL matter, where people went to court and said, listen, our rights have been limited by lockdown, by Minister Nkosazana Dlamini Zuma's lockdown. And in most of those cases, Section 36 was simply not applied for various reasons, but also when there was an acknowledgement that constitutional rights have been limited, the courts applied a very low level of scrutiny, especially in the FITA matter, where the High Court said that yes, the limitation on tobacco sales has this good goal to reduce smoking and boost immunity during COVID. But in fact, this limitation is not reaching what it intends to do. So in fact, people are not smoking less. And when they are smoking, they're smoking black market cigarettes, even more dangerous cigarettes. But nonetheless, the court acknowledged that and still upheld the limitation because it said in theory, this limitation could achieve the result that it intends. So that's a very low level of scrutiny that the courts applied to a government limitation of constitutional freedom. And that really is a problem, given the clarity with which the Constitution spells out how constitutional rights may be limited.
Yeah. When we consider those examples you've given around constitutional freedom, some of the regulations under COVID-19, but also the recent video where the VIP protection unit, assaulted individuals on the highway, would you say that South Africans civil liberties is increasingly coming under threat here?
Absolutely, yes. That's definitely the case, and I think that's unfortunately part of South Africans taking civil liberties for granted. And this is something we really see around the world, where this insistence on being free from government imposition really isn't that loud anymore. But with events like this, tragic as they might be, it does rejuvenate the public and civil society again to say, hey, listen, we are not the subjects of government. We are not the peasants that are to be ruled by this kingly class. We are in fact citizens, and the government is there to serve us. So let this be an example to South Africa as broadly, that listen, our freedom from violence, Section 12 of the Constitution says we have the right to be free from all forms of violence, both public and private. This is a real and important thing that we must insist upon, and we must in fact insist that police officers like these be subject to training in civil liberty, for the police to learn from an early period that we are not there to rule over South Africans. We are there to serve them, to protect them, and ultimately to protect their liberty, not to infringe upon their liberty. But I think this example of what's happened here is in fact a clear example of outright criminality rather than a limitation of civil liberty. And I think the courts, if this goes to court, I really hope these individuals press charges. If this goes to criminal court, then I think the courts are going to pounce hard on these police individuals. So I'm quite hopeful about this one being treated very, very appropriately in our judicial system.
Yeah, Martin, you're echoing the many, voices of South Africans saying they cannot simply be slapped with a notice of intention to be suspended. Criminal charges need to be pressed here. I want to also talk about perhaps some recommendations. Perhaps you have, even as we're talking, but just a clarity on recommendations on how you think then the judiciary can set this right.
Yes, no, the report has many recommendations. The biggest thing is that the judiciary must insist on that higher standard. So when it must always, number one, apply Section 36. There is no discretion here. When a constitutional liberty or a constitutional right has been limited, Section 36 must be applied. It must be applied comprehensively. This is something the courts haven't always done. So there are various elements to Section 36, and each of them must be applied. So the most important one is that if the government has less restrictive means at its disposal to achieve what it seeks to achieve rather than limiting a constitutional right, then the government must do that less restrictive thing, of course, rather than limiting a constitutional right. Now, this is a standard that the courts do not always insist upon, and I would say they must. The other recommendation is not necessarily to the courts, but to Parliament, and that is that Parliament must adopt law that requires of the executive, of ministers, whenever they propose a new legislation, which we have many examples of legislation that in some way limit our constitutional rights, then the minister must, at that point, when the legislation is introduced, justify, according to Section 36, why that limitation is legal and constitutional. And that is simply not done. The Constitution requires that these limitations precede, the justifications precede the limitation, but in fact, usually it's an ex post facto thing where the legislation is adopted. You never hear about Section 36. Only in court it gets brought up, and then there's an analysis. My recommendation to Parliament in the report is that the justification must precede the limitation. The minister must go to South Africa and say, this is how these rules are complying with Section 36, and then it goes through the parliamentary process. So yes, there are various recommendations, and indeed civil liberty can be better protected.
I appreciate you speaking to me about this. Thanks, Martin, the head of the policy at the Free Market Foundation. Martin van Staden, thanks for your time right here on Newslink.